Hello, this is topic 2, the judiciary, institutional powers and constraints, and this is the first of 2 lectures, power of the Supreme Court. One of the reasons I like teaching civil liberties is because civil liberties is about real lives and the real consequences that the Supreme Court has on the lives of people. For example, today we're going to be learning about Marbury versus Madison. And Marbury versus Madison is an incredibly important case, in large part because it establishes the power of judicial review. But at the end of the day, Marbury versus Madison is also about William Marbury, a person who was appointed and nominated to be a federal judge, and he never received his commission, and he never became a judge. So because of the decisions of the Supreme Court, it had real impact on his life. We're also going to be reading about Ex parte McCardle, that case. And while that's an important case for a variety of reasons, at the end of the day, it's about a person who felt that they were imprisoned illegally and unconstitutionally because they wrote opinion pieces in a newspaper. And because of the decision of the court, they can't challenge what they thought was an illegal imprisonment. In the next chapter, we're going to be learning about Barron versus Baltimore, and it's an important case because it's about whether or not the Bill of Rights applies to the states. But it's also about a guy who owned a wharf and who felt that his wharf was destroyed by the actions of the city of Baltimore because of the way the Supreme Court ruled. He was never received compensations for the damages. And throughout those are some of the kind of older decisions of the court that have real consequences. But throughout the course of this semester, we're going to be reading about decisions that say that give you the power to own a legal handgun, legally own a handgun, to obtain an abortion, to wear an armband to school in general, in case of protest, and you can get married if you're LGBTQ. And so, depending on how the court rules, it can have huge consequences on the lives of people. And I don't want you to forget that because it's an important aspect of studying civil liberties. Let's take a quick overview of Chapter 2 and look at the different aspects of power and constraint that the chapter focuses on. The first part of Chapter 2 deals with the power of the Supreme Court. That is the power that the Supreme Court has to nullify law or make law void if the Supreme Court deems that law to be unconstitutional. And that is the power of judicial review. It is a power that the Supreme Court has, and it springs forth from the case of Marbury versus Madison. And so in this lecture, that's what we're going to be spending our time talking about. Another aspect of Chapter 2 is the limitations or the constraints that are placed on the power of the Supreme Court. And so in the case Ex parte McCardle, which is a case following the Civil War, and it's during the era of the Reconstruction laws, the question comes to the court about whether or not Congress can limit the Supreme Court's appellate jurisdiction. And the answer to the question is yes, it can, and we find that answer in Ex parte. And then finally, we're going to be talking in Chapter 3 about whether a case or party can seek remedy at the Supreme Court. That's also another way that the power of the Supreme Court is constrained. And this constraint comes from Article 3. The constraints all come from Article 3 in the Constitution. And so in the second lecture for topic 2, we're going to be taking a look at this thing called justicability and standing to sue. So let's get started. So in Marbury versus Madison, a case from 1803, the question is asked whether Congress can expand the original jurisdiction of the Supreme Court. And the answer to that question is no. Congress cannot do that. Okay, so keep that in mind as we are learning about Marbury versus Madison. On the flip side of that, as I mentioned in the previous slide, that the case Ex parte McCardle asks whether Congress can limit or reduce the appellate jurisdiction of the Supreme Court. Not the original, but the appellate jurisdiction. That's what's known as jurisdiction stripping. And the answer to that question is yes. Congress can limit or reduce the types of cases that the Supreme Court can hear on appeal. As I said, we're not going to be there's not going to be a lecture dedicated to ex parte McArdle, but I will be writing about that in the course overview for the week. Now, as we talked about last week, we've already talked a little bit about what jurisdiction is and how it's defined. Keep in mind that jurisdiction means having the official power to make legal decisions and judgments. And courts have different types of jurisdiction. They have different power as it relates to settling disputes and making decisions. A good example of a court that has limited jurisdiction is a family court. Okay, family courts are courts that exclusively hear cases that have to do with the family. And so they will hear cases regarding paternity, they will hear cases regarding child custody, they will hear cases regarding divorce. But those are the only types of cases it can hear because its jurisdiction extends only to issues having to do with the family. Now, Article 3 of the United States Constitution tells us what the jurisdiction of the Supreme Court is. And it talks about two things. And on the next slide, we'll take a look at the actual language in the Constitution. Article 3 establishes the original jurisdiction for the Supreme Court, that is, hearing a case for the first time, and the types of cases that the Supreme Court can hear for the first time. And Article 3 also establishes the appellate jurisdiction, the kinds of cases that the Supreme Court can hear on appeal. So let's take a look at the language that's in the Constitution. Okay, let's take a look at what Article 3 says about the jurisdiction of the Supreme Court. Now, let me put this is directly from the Article 3. I want to encourage you to read Article 3 in your textbook. It's at the end, the Constitution is at the back of your textbook. When you start reading Article 3, basically what it tells you first is the extent of the judicial power of the Supreme Court. It's telling, the Constitution tells us that the Supreme Court can hear cases having to do with laws of the United States, cases having to do with the Constitution and treaties, cases having to do with maritime jurisdiction, etc. So it outlines a bunch of types of cases that the Supreme Court can hear. It then goes on to say that in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. It can hear it for the first time. Obviously, there are not a lot of times when the Supreme Court can actually conduct a trial, hear a case for the first time. It then goes on to say that in all other cases before mentioned, and that would be the maritime jurisdiction, laws having to do with federal law, laws having to do with the Constitution, and all of other cases before mentioned, the Supreme Court shall have appellate jurisdiction. It can hear the cases only on review, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. And so there's that provision there that you'll be reading about in the case ex parte McArdle that basically says that the Congress can say that certain types of cases are exempt from Supreme Court review, giving Congress a lot of power to sort of define the appellate jurisdiction of the Supreme Court. Okay, so let's get on to the case that we're discussing in this lecture, which is Marbury versus Madison. Now, if we were in class together, and I really wish that we were, that we would start our discussion of this case and all cases by asking you to tell me what are the facts of the case. So in order to sort of simulate that, as you're listening to this lecture, I want you to look at the questions I'm going to ask you. Then I want you to pause the video and I want you to go to the case, and I want you to be able to ask yourself, could you answer these questions, right? And as we move forward during the course of this semester, when we have our group office hours, during those group office hours, we're not going to discuss all the cases that we have in lecture, or in discussion. And so we're going to use those group office hours, hopefully, to go over the cases. And I'll ask you, what are the facts of the case? Because it's a really good way of learning the cases. So, okay, this Marbury versus Madison is about the election of 1800. What's with the election of 1800? Why is it so important to Marbury versus Madison? Who's William Marbury? He's pissed off about something. What does he want? What is he angry about? What's the controversy that he's asking the court to settle? Who's James Madison? Why is he a party to this case? What is the Section 13 of the Judiciary Act of 1789? Now, if you knew that in class, you'd get a giant gold star, but it's important to this case, and we'll talk about it in a second. And then finally, what is a writ of mandamus? Okay, so pause the lecture, look some of those things up in the textbook, and then join back in a moment. Okay, welcome back. So Marbury versus Madison springs out of the election of 1800. And this is a really important election because it's the first time where the sitting party loses to a rival political party. If you are a fan of Hamilton, you might very well be aware of the first two parties of the United States. When the United States was first formed, there weren't parties. But over time, George Washington, Alexander Hamilton, John Adams, they were all aligned with a party known as the Federalists. And to challenge the power of the Federalists, Thomas Jefferson and James Madison form a new party called the Democratic Republicans. And it was a hotly contested election. And if you don't believe me, I have posted a campaign ad from the election of 1800. Yes, they actually made campaign ads. No, they didn't really. But the language that you'll see in that campaign ad is taken directly from the writings of John Adams and Thomas Jefferson about just what would happen if one of those two people became president of the United States. So it was really hotly contested. And so in the election of 1800, John Adams, the Federalist Party, loses, and they have to give over power to the Democratic Republicans. And the Democratic Republicans win big. Not only do they win the presidency, but they also win both houses of Congress. So the Democratic Republicans win big, but the Federalists, they ain't going quietly into the night. Okay, so if you see there's a picture of a duck. And if you look closely, that duck has a splint on his foot. That's because he is a lame duck. He can't walk. Well, what is a lame duck? Well, a lame duck is a person who currently holds office, but they lost their election and they're not going to come back. But there's a period of time between losing the election and actually leaving office that you can do whatever you want without political consequence. And that's what's known as being a lame duck president. Former President Trump was a lame duck president. He lost election in November. He stayed in office until January 20th. And it's at those times that those elected officials can do whatever they want because there's no consequence for it. And that's exactly what John Adams and the lame duck Federalist Congress did. They were like, fine, the Democratic Republicans, they won, but we are not going quietly into the night. We are going to leave our Federalist mark. And the way that they did that was creating a bunch of new courts. They passed the Circuit Court Act of 1801 and the Organic Act at the same time. The Circuit Court Act of 1801, it creates a bunch of new appellate courts, and when you have new courts, you have to have new justices. And the Organic Act basically creates a court system for the District of Columbia, including Justice of the Peace. And so the Federalists packed those courts with federal judges because they really thought, you know what? The Democratic Republicans try to pass laws, they're going to have to face these Federalist courts, and these Federalist judges might very well find those Democratic Republican laws unconstitutional. Furthermore, John Adams replaced the retiring Chief Justice of the Supreme Court with a Federalist, John Marshall, and he's the individual who writes the opinion in Marbury versus Madison. All right, last little bit of historical background. Now, in order to become a federal judge, there's a couple of things that need to happen. First, you need to be nominated by the president. So John Adams nominated a bunch of Federalist judges to serve on these newly created judgeship positions. Next, that nominee needs to be confirmed by Senate. And once you're confirmed, then you're on your step to becoming a judge. But wait a second, there's one final thing. You actually, as the person who was nominated and confirmed, actually has to receive a commission. It's a written declaration that you are, in fact, have been seated as a judge in a particular court. In other words, signed, sealed, delivered, I'm yours. But if you don't get the delivery of your commission, you are not a federal judge. No commission, no judgeship. Now, the Secretary of State is responsible for delivering those commissions, and most were delivered, but not all. William Marbury never got his commission. It was never delivered. John Marshall, the Secretary of State, was responsible for delivering those commissions, and most of them got out. But rumor has it that he gave the final handful of commissions to his cousin, who was a drunkard, and the drunkard was never able to deliver them. When Jefferson takes office, he finds those commissions. They're still sitting on the desk in his office. And he sees them and he's like, hell no, I ain't going to deliver those commissions. They are enough Federalist judges on the court as it is, and I'm not going to add any more. And here are the players. There's John Adams, Federalist president, lame duck. There's Thomas Jefferson, new president, Democratic Republican. William Marbury, he never got his commission. And he was really pissed off about it. And in fact, he sues, as we're going to see, and he's going to ask the Supreme Court in order to issue a writ of mandamus. And a writ of mandamus is an order forcing somebody to do their job. John Marshall hears the case, and James Madison, as Secretary of State, that is the person who would have received the writ of mandamus. If the Supreme Court had issued that writ, it would have gone to James Madison, and James Madison would have had to deliver those commissions. So here we are, left with William Marbury. He felt like he had really been treated poorly. He was nominated and approved by Senate to become a justice of the peace, but he never got his commission, and he thought that that wasn't fair. And he was looking for some remedy to this situation. And so he looks through the laws of the United States, and he comes across the Judiciary Act of 1789. And in the Judiciary Act of 1789, in particular in Section 13, it says that the Supreme Court has the power to issue a writ of mandamus. And William Marbury thought to himself, he's like, okay, this is the solution to the problem. That a writ of mandamus is where a higher court, like the Supreme Court, makes a public official do their job, like James Madison, delivering that commission that is owed to William Marbury. And so he takes action, and he asks the Supreme Court to issue a writ of mandamus, setting the stage for Marbury versus Madison. The question before the court in Marbury versus Madison is, does the Supreme Court have the power to issue a writ of mandamus in order for an appointed judge to secure his commission? And the court holds in a 4-0 ruling that the power for the Supreme Court to issue writs of mandamus is not in the Constitution, and therefore Section 13 of the Judiciary Act is unconstitutional. John Marshall writes the opinion of the court. So how does Marshall reach his decision? Well, as you're reading the decision, you'll note that he asks 3 questions. The first question that he asks is whether or not Marbury has a right to his commission. And he says that yes, absolutely he does. He was nominated, he was confirmed by the Senate, and therefore it should be seated as a judge. So yes, he does have a right to the commission. The second question that John Marshall poses is that if he has a right to the commission, do the laws of the country afford him a remedy? And the answer to that question is yes, absolutely. That when somebody is treated unjustly and unfairly by being denied his judgeship, that in fact that is illegal, and the country should do something to remedy it. So the third question that Marshall asks is, okay, so is the remedy to this situation the Supreme Court issuing a writ of mandamus to the Secretary of State, James Madison? And he says, no, it is not. Why? Well, he says that Article 3 of the Constitution establishes the original jurisdiction of the court, not Congress. Section 13 of the Judiciary Act expands the original jurisdiction of the Supreme Court, giving it the original power to issue a writ of mandamus. Keep in mind, this case about William Marbury was not heard by any other court. It was going directly to the Supreme Court and asking the Supreme Court for remedy. That's it, placing it in its original jurisdiction. Marshall says that the Constitution does not give Congress the power to expand the original jurisdiction of the court. Therefore, that provision of the Judiciary Act of 1789 is unconstitutional and null and void. No commission for Marbury is going to be delivered, at least not through forcing the Supreme Court to issue a writ of mandamus to James Madison. Sad face. So why is Marbury versus Madison important? It's important because it establishes judicial review, and that's why you learn about Marbury versus Madison in any American government class. Judicial review is the court's power to invalidate actions of Congress, the executive branch, or states and local governments if their actions or laws are deemed unconstitutional. And it's a tremendous and important power. Throughout the course of the semester, you're going to be reading cases where federal law, state law, city ordinances will come to the court, and the question will be asked, are these laws constitutional? And if they are deemed unconstitutional, they are nullified by the court. But this is also an important case because John Marshall, in his opinion, provides a vigorous defense of the Constitution, of the separation of powers between the legislative branch and the judicial branch, and really makes a strong case for why it's so important to have a Supreme Court, because without a Supreme Court determining the constitutionality of law, then it's very, very hard to have a democracy. So if you will indulge me, sorry about the noise in the background from my crazy dog, we're going to read verbatim some of the most important points that John Marshall makes in his opinion, and you will find these on pages 50 to 52 in your textbook. John Marshall writes in Marbury versus Madison that the people have an original right to establish for their future government such principles as, in their opinion, shall most conduce to their own happiness, is the basis on which the whole American fabric has been erected. He writes about that, the importance of the Constitution and the Constitution being followed. And that comes straight out of the Declaration of Independence. For those of you who took American government, you will see that those are the words exactly in the preamble to the first few paragraphs of the Declaration of Independence. So he's basically saying that we need to abide by what is in the Constitutions because it's people who are writing that, and it's the basis of our democracy. He also writes that the principles, therefore, so established are deemed fundamental, and as the authority from which they proceed is supreme and can seldom act, they are designed to be permanent. Because the big question in Marbury versus Madison is, if Congress passes a law and it's not constitutional, do we still have to treat it like it's law? He's basically saying no, that the Constitution is supreme, it's permanent, and it's very important and fundamental, and therefore it should be followed. And then he goes on to say the Constitution is either a superior paramount law, unchangeable by ordinary means, acts of Congress, or it is on the level with ordinary legislative acts, and like other acts, it's alterable when the legislature will please to alter it. And he feels that that's really, really dangerous, right? That why even bother having a constitution if acts of Congress supersede the Constitution itself? And finally, Marshall states, if an act of the legislature repugnant to the Constitution is void, does it, notwithstanding its invalidity, bind the courts and oblige them to give it effect? Or in other words, though it be not law, does it constitute a rule as operative as if it was a law? This would be so overthrown in fact that was established in theory, and would seem at first an absurdity too gross to be insisted on. So I hope you find some time to actually work through the ruling, the opinion of John Marshall. Let me just say that opinion is a lot more difficult than reading it. It's pretty difficult. Keep in mind it was written in 1803. And so earlier in the semester I said Supreme Court decisions are easy to read. They are much easier than the one that you read in Marbury versus Madison. However, it's still worth your time. Well, we'll conclude here by just thinking critically about judicial review and, encouraging you that this is the kind of question that will be on the midterm exam. I want you to think about what are some of the benefits of the Supreme Court exercising judicial review and what are some of the drawbacks. Your textbook talks about, here you have this unelected judicial body that serves for a lifetime, and they have the power to overturn the actions of elected legislative bodies. So you could, in theory, have, 100 senators and 435 members of Congress all vote in favor of the law, and then you could have 5 out of 9 justices say that law is unconstitutional. So sort of think about the implications for that. And think about, are there any checks on the Supreme Court power of judicial review? If the Supreme Court rules that something is law is unconstitutional, is there any check on the power? And are there adequate checks to prevent the Supreme Court from abusing its power? And let me just draw your attention to the tiny print here. Okay, I'm not expecting you to read that, but there is a whole table in your textbook that does a really good job of looking at the pros and cons of judicial review. All right, thanks a lot. Hope you liked learning about Marbury versus Madison, one of my favorite cases. Okay, talk to you again soon.